Good morning, everybody. We are just about ready to get started. Let's get the last few things organized. This is going to be a super important topic today, very timely. All righty, it's 7 a.m. in the morning. It's fine morning. I'm excited to be talking about some buyer broker agreements today. I titled this presentation A New Necessity. I think that these are going to be extremely important to your practice going forward. So we're going to go through them, talk about what they are and how to use them. Of course, I am an attorney, so we're going to start off with a disclaimer that I'm giving you advice, but it's not legal advice and it does not create an attorney-client relationship. And of course, as we're going to discuss, this is an ever-evolving area of the law, so be very careful. A little bit about me, of course. I'm licensed for 20 years now as an attorney, and I specialize in real estate law. Currently, I'm chair of the Legal Resources Committee for another month, and I serve on the reptile section of the bar, so I'm familiar with the Farbar Agreements as well. Um, Today, we're going to talk in some detail about the NABOR and Farbar buyer broker agreements. But before that, I'm going to give you a brief overview of some recent court cases against realtors. I'm sure you're all familiar with them. Then we'll try to talk about some tips and some tricks from my research on how to navigate this new world of buyer broker agreements. So, right off the bat, let's just talk about the legal actions against NAR. Let me get my slide to advance. There we go. And how they affect the way you do business. There are now 8 big lawsuits, one of which has already gone to judgment. And in the Burnett Seitzer verdict, of course, a federal jury in Missouri found that NAR and several brokerages were inflating real estate commissions. After a 2.5-hour deliberation, the jury came back and was unanimous that NAR and the other defendants, the other brokers, were guilty, and they awarded $1.78 billion in damages, which, of course, because it is a federal case, antitrust, it can be trebled to $5.3 billion in damages. So this is a big deal, and it's going to change a little bit about the way we do business. Not sure how much yet, of course. The interesting thing about the lawsuit was that immediately after the verdict, the same lawyers filed another lawsuit, and now there are 8. So it's going to be an interesting few years for NAR and realtors. This all shakes out. Of course, the first judgment, like I said, is already in the books, and we're just waiting for the judge to finalize his ruling. In addition to the civil lawsuits, the Department of Justice is also probing commissions for NAR, and they are working with the Seitzer Burnett plaintiffs to come up with some language for the judgment. I'm sure that's going to be a very interesting read for realtors to understand what you're going to be able to do in the wake of these lawsuits and with the Department of Justice trying to break its agreement with NAR. So I'm not a class action lawsuit expert. I'm a real estate transaction expert. And so we're not going to spend a lot of time talking about these cases, but you need to know they're out there and they're going to affect the way you do business. And the point of today's presentation really is to talk about the way you do business when you represent buyers. When you take buyers out and you show them homes, what are you going to do to to protect yourself and your broker from liability. Make sure that you're upfront and honest with the buyers about the commissions. And that's pretty much the gist of it. We're going to go through these agreements. I'm going to walk you through the agreements, and like I do in some of my other presentations, we talk about the parts of the contract. We're going to do Farbar and Nabor, and then we'll talk about the terms and everything and some tips. So right off the bat, digging into the top line of the contract, you've got your buyer, you've got your broker here. You enter the buyer's full name. Of course, if it's a trust or an LLC, you need to make sure you've got the right party as your buyer so that you can be sure to earn your commission. Enter the full legal name of your brokerage. So I see some people will just put, for example, Remax. Well, if it's Remax Affinity, or is it by the beach or by the bay, make sure you get your full broker name in there so you have a legal contract. So probably the most important part of this contract is what you do for your customer. And they define it right in the contract, what your roles are. And you are there, as you would imagine, to assist the buyer in acquiring an interest in or right to use real property. Acquiring an interest in or right to use real property. And you find the properties based on the buyer's criteria. They talk about desired properties and making the broker's best efforts to identify and locate properties suitable to purchase. And then you prepare and negotiate the sales contract, which of course you've always been doing, but now it's in writing. And you are actually, the nice thing about both Farbar and Nabor's buyer broker agreements is they are there to protect you and your broker, as well as outline what you're going to do for the customer. You are actually allowed to other potential buyers maybe looking at your property that you're showing, and you can help them make offers as well. So it's exclusive, as we're going to talk about, but it's not exclusive specifically to you can help others, but they have to work with you, is what I'm trying to say. So then we talk about the brokerage relationship in the contract. Right up front in the contract, the buyer broker agreement, you want to make sure that you're clear as to what your role is. Of course, you could be single agent, you could be transaction agent, you could have a no brokerage relationship. Single agent, it's not a class on agency per se, so we're not going to get too far into it. But the most important thing, I think, is talk to your broker about what they want you to be. Most brokers are going to tell you to be a transaction agent, transaction broker, because especially in a large brokerage, there are going to be other realtors looking at this property, and other realtors could be another listing in your brokerage from another realtor. So just plan on being a transaction agent unless you're a single agency brokerage or you have a no brokerage relationship with them. So an interesting point about these agreements is they actually also spell out what the buyer agrees to do for you. The most important thing is the buyer agrees to work exclusively with the broker during the term of the agreement and be available to evaluate and view properties exclusively with the broker and not any other broker, selling licensee, owner, builder, etc. So it's very clear. Once the buyer signs this contract, they're your customer. You are responsible to get them a house. They are responsible to work with you. And you can explain this to them. I'm going to use all my efforts. I'm going to talk to many realtors and many other people on your behalf to get you the house that you want. But I need you to work with me, because they're going to be running around talking to other realtors, talking to builders, looking at other properties. And they also need to know, as a part of that they will notify on all occasions other brokers and third parties of the existence of this agreement and the broker's exclusive brokerage relationship with the buyer. So they are supposed to refer you all inquiries about any properties. They're supposed to provide reliable financial information and general information about what they're looking for. Of course, this is the NABOR form. It's a little different in the Farbar form. We'll get to that in a few minutes. But again, that exclusively work with you. So you sign up a buyer, you put them in your car, you drive them to 200 properties over 3 months, and then you expect to get paid. This gives you a little bit more cushion to make sure that they're not going to go backdoor you and work with another realtor. The term of the agreement is typically 180 days. That's the default. Of course, you can work with them on whatever time frame you like. It may be they're going to be in town for a weekend and they don't want to sign up for a long-term commitment. I will say, obviously, if you can get them in there a little bit longer, then you have more time to find them the property. And of course, that's helpful to your business and create some continuity for your buyer. This agreement automatically extends if you get a contract signed and the agreement expires. So you don't have to worry about getting extensions in this contract. You come to the end of the time period, the term of the agreement, and you finally find the home that they're looking for and they're really excited and they want to get a contract in. You don't have to worry about getting this agreement extended. It automatically extends. It also has a protection period, so they can't go behind your back and try to better deal you for so many days here after the termination date. So if you show buyer a property, they can't come back and after your term is up, say it's a shorter term, and go to the seller and say, you know what, I'm going to buy this property from you and I'm not going to use a realtor so you can give me a better deal on the commission. Unless they sign up with another broker who takes them to the same property. So you got to be careful there. So the most important part, I think, of this agreement for you, of course, is your compensation. Works similar to a listing agreement. You put the percent that you expect to be paid by the buyer, not by the seller, by the buyer. And of course, we'll get to the seller helping in a minute, but paid by the buyer. And if there's a fee or a flat fee, if you're just going to take a small flat fee, for any commission, and then of course any rents that if you find them a rental, you get paid as well. So the broker's compensation is paid on any real property purchased, placed under contract, leased, or optioned by the buyer or any person, entity, assignee, successor, and interest nominee of the buyer. So it's very broad language there that we don't want them forming an LLC that's not part of the buyer broker agreement to get out of paying you. And you get paid for any transaction in real estate this buyer does during the term. You get paid at closing or occupancy, or if the buyer defaults on the sales contract. So say the buyer just walks away from their deposit, you're entitled to this percentage that you've put up here. And you get any excess commission offered by a seller. So you put X commission in this box, and then the seller offers X plus 1. You get X plus 1, and then the buyer does not have to pay you because the seller has paid you. But at least you're upfront about it, and you discuss this with your buyer so they are aware of what's going on. And you get the difference from the buyer. If the co-broke is less, then the buyer's got to come to closing with some money to pay you. Okay. Additional terms to protect, again, designed to protect you. Oops, mouse is not working this morning. Additional terms, presently there is the option to lien the property if that is purchased. If the buyer does try to better deal you, I would expect that will probably not stay in this NABOR agreement, just because the committee is going to meet on and modify these agreements. We've heard some pushback about the idea that you could lien the property. Buyers don't want to hear that. You are held harmless for professional mistakes of others if you give like a recommendation. So say you refer title business to some bad title company, not me, of course, and they do a bad job, you can't be sued by the buyer for that referral, and that's going to be important. Of course, fair housing, you are not going to be obligated to discriminate. You know, they say, I don't want to be in such and such a neighborhood. You are not obligated to follow those instructions. The nice thing is the prevailing party gets their attorney's fees paid if you do end up in a lawsuit and you win. So you would get your attorney's fees paid. And then, of course, if you lost the lawsuit, you would pay the buyer's attorney's fees. So be very, very careful. And a cooperating broker disclosure, just to let the buyer know that it is your broker's policy to cooperate with other brokers in the marketplace, regardless of the relationship, provided that it's in accordance with the buyer's instructions. So if the buyer tells you, you know, please don't go to such and such a brokerage, you would want to follow that, but you would not be obligated to follow that. Now, the next part of the NABOR agreement talks about is the signature block. Notice on the signature lines, of course, the buyers sign, put their address, their contact information, their email, and then the broker signs the contract, not you, the broker. Your name as the realtor goes over here, and you put your full brokerage name here. So the broker would sign. So you got to get a DocuSign for the broker. That's always fun. Okay, let's talk next about the buyer broker agreement for compensation. This is a NABOR form as well. I just want to say one thing about this form. It should not be confused with the exclusive agreement that we just talked about. This is a one-time agreement, typically for your transaction fee. When you don't have a buyer broker agreement and the seller is paying the commission, you put your transaction fee there, and that's really what this is for. So don't get this confused and think you put a big number up here and that's what you're entitled to. It would be if you did that, but it's not typically what this form is used for. So when you're sorting through the forms folder, I just didn't want you to be confused if you saw this form in there. So those are the two big NABOR forms for buyers and brokers. I'm going to switch over hat to Farbar now, and let's look at the Farbar agreements. So Farbar actually has 4 versions of their exclusive buyer brokerage agreement. I hope everyone's enjoying their coffee because it is very early this morning, although I'm trying to move through this so that you can all go back to bed. Just kidding. I know everyone's got a busy day. I know how you guys work so hard. But anyway, so section 1 through 11 of the Farbar agreements are all the same. Then section 12 defines the relationship. And again, there are single agent, transaction broker, no brokerage relationship, and the consent to transition to transaction broker agreements. So I'll say one thing real fast about the last one here, the consent to transition to transaction broker. As you all know from your licensure classes, you have to be you are a transaction broker by default. And then if you want to transition from single agent, if that's what you started as, to transaction broker because you found the buyer and you want the buyer to sign something, you would use the transaction broker transition one. So let's talk about the Farbar agreements. First of all, a little different with the signature lines. Put your buyer's names up here. You put your broker name here and the office name here. And again, it's the exclusive right to work with and assist the buyer in locating and negotiating the acquisition of suitable real property as described below. And they really broadly define acquire and acquisition to mean purchase, option, exchange, lease, or other acquisition of an ownership or equity interest in real property. So they really want to tie up the buyer and make sure that they know they're going to exclusively work with you. And the term, of course, there's no default, so you must enter your time periods beginning on the first day of the month in the year, and it terminates at 11:59 on the day, month, year. However, if buyers enter an agreement to acquire property that's pending as of the termination date, there's an extension like neighbor to continue the transact until the transaction is actually closed. Notice there's no protection period in the Farbar contract. It actually comes later in a separate section. So Farbar also protects you. And by the way, people always ask me, Sam, what do you like about, which set of forms should I be using? Well, I'll say this very much with the buyer broker agreements, different than the sales contracts. They're very similar, and I like them both. They do things a little differently, but ultimately you reach the same conclusion. One nice thing about the Farbar contract is here, section 3, they give you a little more room to describe what the property is, what the buyer's property is going to look like, what the buyer's looking for is what I'm trying to say. So you describe what the buyer's looking for. There's a type, you write condo, townhome, single family, HOA, whatever it is. Describe the type of property here. The location, I would be general in the location. Write Naples, which of course could be all of Collier County. Write Fort Myers, and it might not include Lehigh or the Cape. So be careful how you write the location. I would be as broad as possible. Then pick their price range, whether they've been pre-qualified. It's a reminder actually to get with the lender early. Remember, your sales contracts all expect that your buyer has got some knowledge of their finances and their insurance. So this is a good opportunity to have that conversation and find out if they're pre-qualified or pre-approved. And then you've got your preferred terms and conditions. If there's anything in particular that this buyer needs to deal with, pre-closing occupancy, sale of a home, any of the addendums that we have for buyers in the forms. Scott is asking me, can we mix and match? If you are showing a listing and say you're in Bonita and they want a Farbar form and you're on a neighbor buyer broker agreement, don't worry about that. You can mix them. You can mix neighbor buyer broker agreements with Farbar contracts for sale. They don't refer back to one another. Stephanie's asking if the exclusive buyer broker agreement will be mandatory with neighbor. I would say no, Stephanie. I cannot speak for the board, of course, but I don't think anyone's going to mandate these, unless I should hold on. Let me pause. The lawsuit may mandate them. The judge has that power to issue injunctive relief. So we will see. Chris is asking, will a buyer broker addendum be created to attach to contracts? No, Chris, you would not attach this to a contract. This is a separate contract between you and your buyer. The sales contract is a separate agreement between the buyer and seller. So they don't intermingle and they don't connect. So what are the broker's obligation? Yes, Chris, the compensation will show on the settlement statement. And then Stephanie, you're asking me if a potential customer asks about the lawsuits, what's a good general answer? Tell them that realtors are working it out and that you are going to be upfront and honest with them, that you're going to explain your role and prove your value. That's all you can really do at this point until we get that order from the judge and we know exactly what's going to happen, and it's going to probably include everything from the Department of Justice. I think you just be upfront. Some realtors were sued for not being honest. I'm an honest realtor, and I'm going to explain to you my role and what I can do for you. And speaking of your role, look right on the screen. You can see what your job is. The Farbar contract lays it out. You're going to use professional knowledge and skill. You're going to assist the buyer in determining their financial capabilities and financing options. That means talk with a lender. Remember to always be the source of the source. You're going to discuss their property requirements. You're going to talk about you're going to assist them in the contract. You're going to monitor deadlines. So you do a lot for these buyers, and you deserve to be paid for it. Um, and it protects this contract protects you again from Housing Act violations. You are not obligated to discriminate, even if your buyer asks you to. I think that's very, very important given what's going on in the world these days. And you are relieved of liability for making referrals right here. And then we have some more questions. Will the listing agent be able to change the offered co-op commission when the buyer broker compensation is revealed? Chris, that's a great question. No, that would be, at least in the NABOR MLS, that would be a violation of policy, and the listing agent could be sued by the buyer's agent. Sharon, what you're asking me here? If we sign a NABOR buyer broker agreement and we only find property in Lee County, do we need to sign a Farbar? No, you do not need to switch. That's a good question, Sharon. Just because you're in Collier County on a NABOR form doesn't mean that you're not able to show Lee County properties. The contracts are valid across the state of Florida. You are protected during the protection period, Sharon. Okay. So what does the buyer have to do in the Farbar contract? Well, they have to cooperate with you. They have to conduct their negotiations through you. They have to advise other realtors that they have a realtor, that's you. They have to provide accurate information. And I find it interesting in the Farbar contract that the buyer authorizes the broker to run a credit check and verify buyer's credit information. So you can actually make sure that your buyer is who they say they are and they can afford what they say they can afford, so that they're not wasting your time. I think that's kind of a big deal. Also, the broker is indemnified. You are indemnified while acting on the buyer's behalf in this agreement. Another big deal. Anything that any damage the broker incurs while acting on the buyer's behalf, the broker can collect from the buyer. So it's a pretty comprehensive set of buyer's obligations. The next thing that this contract does that I like is it provides for a retainer. So you're going to pay out for gas. You're going to go do all these things for these buyers. You actually, in the Farbar contract, can collect a small amount of money, I would say, although any amount is allowed, for broker services. And then you can put it that says the fee is not refundable, and you can check the box whether they get a credit for it or whether it's additional compensation to be paid to you. So think about that for a second. This is going to be a tough one. And I would say, given the competition for the number of realtors, this retainer section is probably not going to be used that often. I have not seen it used, although again, we're entering a new world. So I'd be curious to hear your feedback from all of you once this is paid. Cindy, the retainer goes to the broker, and then of course you would be paid as part of your IC agreement with your broker. So compensation, a little bit different than the NABOR. The commission is earned when the buyer contracts to acquire property. When the buyer contracts to acquire property, this commission is earned. And again, you would enter either a flat fee or a percentage here, and then, or next up, you can enter a flat fee here or a percentage here, plus like if you have a transaction fee, it would go
increased volume.
And that's probably going to be the one that you use, is this last set of blanks here, where the transaction fee is paid on top of the commission. Most brokerages now charge a transaction fee. And then of course the commission is due on the default. So that's very good. If the buyer tries to walk away, you still get paid. Chris is asking, until standards of practice established, buyer's agent can receive compensation for buyer and from the seller through the co-op commission. No, Chris, that's not correct. These agreements all say that if the seller pays you, then the buyer doesn't have to pay you. You don't get a windfall as a realtor. You get paid your percentage of or your flat fee based is on whatever's being offered in MLS. And if it's offered in MLS, Chris, then these contracts say the buyer is paid. The buyer doesn't have to pay you. The seller pays you. Okay, this contract also contains a protection period, which we said are, in NABOR it's up front. Here it's further down in the contract, but you put the number of days after the agreement terminates that you want your buyer on the hook to pay you if they go back and try and deal behind your back. Again, NABOR says 180 days. I'm not sure that you're going to get away with that with the sophisticated buyer, but it's possible. And of course, the same is with the listing agreements and everything else. The protection period ends if the buyer gets a new broker. Again, there's a dispute resolution provision, early termination. If the buyer terminates, which they can do at any time in this agreement, which I find to be interesting, buyer may terminate this agreement at any time by written notice, and then they would still owe the compensation during the term plus the protection period if they went back and tried to better deal you again. So the buyer can terminate the agreement, but then they cannot go back and take buy a property that you showed them until the protection period expires. And this contract calls for mediation followed by arbitration if there's a dispute. And of course, the broker can assign the agreement if you sell your brokerage or your broker gets bought by somebody else. Then you can assign the agreement. A couple of more questions here. Cindy, the retainer is paid when the contract is signed. Betty, I am not going to make a suggestion for the protection period because I don't want to be accused of violating any antitrust rules, but I will tell you that the default in the NABOR agreement is 180 days. And so pick whatever it is what do you feel comfortable tying your buyer up for or whatever they agree to. Chris is asking about the termination. Yes, they can terminate without cause, Chris. You are just protected if they go back on you. What if the buyer agreement is written that you expect to be paid Z, whether from the MLS or added to by the buyer? That's correct, Ella. Again, these agreements say that if the seller pays a co-broke, then the buyer would not pay unless the buyer owed more than the co-broke. So, and the retainer fee, Nicholas, again, is paid to the broker. So this, like I said, the Farbar has 4 versions, and they break down with the brokerage relationship. So you basically have your 4 choices. So make sure you're using the correct form. I'm going to tell you right now, 99% of you, with your brokerages, are going to be using the transaction agent version. So be very careful if you use the Farbar form as to which form you pick. Make sure that you talk to your broker. Check with your broker. Please don't screw this up and get your broker sued because you signed a single agency with the buyer when the brokerage had the listing. And remember, single agency has to be in writing. And then, of course, the statutory default is to transaction broker. On the signatures, again, this is the buyers sign and date. The broker signs and dates, but you as the sales associate also sign and date. So this is on the Farbar, you sign with your broker. And Peggy, it says that where does it specifically say the seller pays, the buyer doesn't pay? It says it in the compensation section. Michelle is asking, can you tell us the benefits for the buyer to sign a buyer-broker agreement, risks, pitfalls without signing it? What have you seen in your practice? Well, I'm going to do you one better, Michelle. Let's talk about some tips and tricks to getting these things signed. Let's talk about your value as as a realtor, which from my perspective, by the way, having done thousands and thousands of transactions with realtors and hundreds of transactions without realtors, it is so much better to have a realtor involved. Both sides, working for their customer, bird dogging documents, maintaining the relationship. So I just, as I'm seeing some of these comments, um, you guys provide so much value. It's fantastic. Della, I'll come back to that at the end. So let's talk about how you can bring value. Number one, stay educated. You got to know what you're selling. You've got to be educated. Your buyer's going to be Googling. Your buyer doesn't know what they're talking about. You need to know what you're talking about. What does that mean? Local market knowledge. You got to know what you're selling, inventories and options in their price range, how to make offers, the process. All this stuff I have listed here, knowing the local terrain, literally knowing the terrain for flood zones. How high is this property elevated? Literally knowing the local terrain, not just euphemistically knowing the area. And you need to be prepared to give advice, consult, and provide insight on all things real estate. So, and I'll tell you right now, just for my part, I read Housing Wire, I read Inman News, I get Google alerts set up for various subjects. It's super important to know what's going on. Yes, and you need to know where the wetlands and the gophers are. You really do. And that's your value. That's really your value. Your buyer is not going to study wetland regulations. You got to do it. And then you get paid to do it. The other thing you got to do is you've got to be accessible. The market moves fast. Your customers moving fast. And you know it, I know it. Those of you that get my emails, you see it. It's a 24/7, 365 job. And I love this quote. I stole it out of Inman. There's no other profession with the burden of accessibility and availability does not receive any compensation for their time up front, no matter the ultimate outcome. Perhaps this will change with the use of buyer broker agreements. So I don't understand why you would never use them from the beginning, but I get the market and I understand that it's tough and there's a lot of realtors, but this is going to be a new thing and then we're all going to have to do it together. Next up, learn to research. If you're not good at research, get good at research. You have to know a lot of things. And you know a lot about a lot of things. Your communities, the rules, the regs, the covenants, the budgets, the HOA dues, special assessments, pending litigation. That's just in the HOA. Then you've got to check, you got to know building codes. You've got to have insurance people who can figure out if they're in a flood zone, what the fire and hazard insurance is going to be. You have to learn to understand deeds and surveys. You don't have to be title agents, but you have to know what questions to ask so that you can at least find out who to put on the sales contract for the listing. So you can get the right seller. And I talk about that in some of my other presentations. Yes, Cindy, Surfside, hurricane insurance, all of it. You should be able to read through title and read a title commitment. They're very simple documents. It's basically two lists of documents in one as the title commitment. And then always remember to be the source of the source. Know who to call to solve the problem. And I think that's super, super important. Yes, Cindy, I could do a title commitment class. My slide's not advancing. Okay. The next thing is build a relationship that lasts. So many times, we get short-sighted and we don't think about what it is that we're doing. The name of the game is your reputation for getting the deal done. It'll bring you clout with listing agents. And again, be the source of the source, be the problem solver, and be an indispensable resource for your customers. So before I take questions and everything, and just put this quote that was also from Inman. Buyer's representation is quite comprehensive, involves ongoing communication, being extremely proactive, problem solving, troubleshooting, double and triple checking, following up and assuming nothing has been purported to be. Buyers don't know what they don't know, and those who don't have representation often find themselves in a problem or situation that can have serious financial implications. That's probably your base value add. You are going to save your customer money. They're going to pay you, or the seller is going to pay you, but it's going to cost them less than if they didn't have a realtor and they got screwed over by a listing agent or by a seller or by a lender who didn't, and they didn't ask the right questions. Your expertise is your value. Okay, let me go back through some of these questions. Somebody, VA buyers can't use them. Roy, I'm not familiar with the VA rules regarding buyer broker agreements, but if we need to look that up, I can get an email out on that effect. Go ahead. If you want to unmute yourself and ask a question, feel free.
Sam, I'm going to tell you that the VA in Washington, D.C. is going to have to change their policies in order for a veteran to be able to pay the buyer's agency side.
Oh, yes, yes. Yeah, that is true. That is a big issue, Cindy. Thank you for raising that. It's not whether the buyer can sign the agreement so much, but what can the buyer pay at closing? And you're right, the VA regulations make that very limited, FHA. And I'll say this, the co-broke really gets the low income first time home buyer to the table. Because if you're on an FHA loan and you can barely afford the 3.5% down payment, plus the closing costs, which probably are going to be financed anyways, you know, they're not going to be able to pay a buyer's agent if the seller doesn't pay. So there's going to be a few things that have to be worked out in the regulations for federal loans. There's going to be a few things in the way down payments work, whether these commissions are financed. So it's going to be a big deal. Roy, I see you're unmuted. You got a question?
No. I'm glad she clarified that, because 80% of our customers are VA, and the VA regulation says, they can't pay a buyer's agent. And I'm waiting for somebody, because I've addressed this to a bunch of different people, to give a plausible workaround for that.
So this
Yeah, I'm not sure what the workaround is going to be, Roy, but they're going to have to do something, because especially if the judge orders, hopefully the DOJ is advising the Seitzer Burnett plaintiffs on that issue, because I believe that they're aware of that.
I
Andrew,
talked
you have a
to
question?
Yes, Sam, if you get a seller credit to the VA buyer, is the VA buyer able to pass that on to a brokerage fee or no?
Well, yeah, if the seller pays the commission, then the commission would go to the buyer and the selling realtor like normal. The only question is what happens if the listing agent offers, one amount and you've agreed with your buyer for a higher amount on a VA loan. The buyer probably is not going to be able to come to closing with the higher amount. So as the buyer's agent, you're going to take less.
But to protect us or our brokerage for whatever that verbiage is, do we have to have anything specific in there? Like, this is the example. Listing agents paying a buyer agent commission of 2.5%. We say seller to credit buyer $2,400 at closing to go towards closing costs and prepaids. Do we need to change that verbiage to
no, you can still
actually
do that.
Being a buyer agent commission?
No, you can still do that.
Okay.
Yeah, that's fine. Okay, Nicholas, you raise your hand.
Yeah, so is the retainer, does the buyer write a check to the brokerage, to the broker, and then where is it held? Can it be spent right then and there for
the Farbar form is not specific about when it's paid out. I think it's paid at the beginning of the process. So your buyer would write a check to the broker, to the brokerage, at the beginning of the process, and then it'll be between you and your broker as to when you receive the funds. I would say that if I am a selling agent and I've got a buyer and the buyer agrees to the retainer, I'm going to go to my broker and say, I need this money now because I got to pay for gas to drive this guy around. So that's probably what I would do.
Okay, so you're allowed to receive those funds
Yeah,
it's
you
not
can
considered
receive them whenever your broker gives them to you. Yes.
Okay, great. Thank you.
Yep. Cindy? Oh, Cindy, do you have a question?
I was going to say on his question about the VA, I spoke to a lender that does predominantly VA, and he went to his biggest underwriter for VA loans. His answer to the question was VA limits 4% prepaids until closing toward the buyer's prepaids and closing costs. So if we have to come up with closing costs and stuff for that VA buyer, adding the commission to that still has to be within that 4%. He also suggested that we contact our Washington, D.C. people and make them aware so VA can get notified, because it'll take 10 years for VA to get their crap together.
Yeah. No, I agree with all of that. So you're going to be limited on those VAs. So a lot for those of you that do a lot of VA work, this is going to be a tough road. It's going to be a tough road for the next few years. That's true. All right, we have some more questions. Let me go through them. Can you discuss the flip side of this when getting a listing explaining buyer's commission to the seller? How do we approach this? Batya, you just need to go to your seller and say, listen, I'm going to be offering a portion of my compensation to the buyer, and you need to be okay with this. And they usually are. I've not heard, although I could be mistaken because I obviously don't sell, so I'm not in a lot of listing appointments. But you just need to explain to your seller it benefits them for you to offer compensation to buyers' realtors, because then buyers' realtors bring buyers to your property. So, I mean, that's kind of how I would approach that, although I probably would look to some guidance from some of the more seasoned realtors on this call if they've got any thoughts. What do you say to a buyer now, to your sellers now, about paying buyers agents now these lawsuits are out there? So Michelle is asking, when appropriate, your perspective on Fort Myers being included in the NAR lawsuit settlement this rule for the plaintiff. Michelle, I wasn't aware that Fort Myers was involved in the NAR lawsuit. I thought it was against NAR and several brokerages. I'll go back and look that up. I've got to pull all the pleadings. It's only about 10,000 pages. Other questions? Anybody? Thoughts? Concerns? I'd love to hear your concerns. Carol?
When we, that one, the neighbor one talks about them not working with builders. And when we work with builders, they do have an agent at the builder side. The builder pays our commission, you know what I mean? They're the seller.
I didn't see anything in there that said not working with builders.
In other words, if we take the buyer to the builder, they compensate us and we work with the buyer, but they really do the contract and everything else. So
Right.
They have to still work with the builder's agent. I mean,
Buyer's agent. Yeah.
yeah. I mean, yes. So, but in the neighbor one, it said that they can't work with any builders.
I didn't see where it said that in the neighbor agreement. It just said that the buyer agrees to work exclusively with the buyer's agent. Is this what you're talking about here on this slide?
Yeah.
No, you can certainly take your buyers to go see new construction, and you should get paid appropriately. What this agreement says, Carol, is that if the seller doesn't pay you, the buyer does. That's really all this says. It just guarantees that you get paid for your work.
Okay.
Yeah, they all say that. Bob is asking, can we still recommend to the seller to offer buyer compensation to generate more interest in their property? Bob, absolutely. So far, let me be very, very clear with you guys. Nothing has changed. There was a lawsuit, NAR got sued, $1.78 billion was awarded. But right now, as we sit here talking about this today, nothing has changed yet. There will be changes. We're preparing for it. We're trying to be proactive. But right now, you can certainly do seller compensation to buyer's agents. Hold on, Paula is asking, if there's no compensation offered in MLS and you have a buyer agreement, can the offer include compensation sellers to pay? Absolutely, Paula. You can that, and it's going to be a lot more like the commercial world. You're going to be negotiating commissions. That's just the way it's going to be. And that's what these people want, is they think the commissions are going to go down because there's going to be more negotiation over commissions. So that's really the future. The details of the plaintiff's lawsuit listed Fort Myers, the covered MLS, and the lawsuit listed on Cohen Milstein website. Okay. Oh, that's one of the new ones, Michelle. The Moeller lawsuit. I have not seen Moral yet. I'm working on that one. Again, 8 new lawsuits all filed in the last 2 weeks, so it's a lot of reading.
Hey, Sam,
Yes, sir.
question.
Yes, sir.
On page 1 of the Farbar form, can you be too general? In other words, if I say location, Southwest Florida, price range between $200,000 and $5 million, haven't I kind of made it too general at that point in time? Have I formed a mini monopoly by saying you can't work with anybody else on anything?
Well, you've already said that, Roy. This is an exclusive agreement. When your buyer signs this agreement, they agree to work exclusively with you for you to find them properties. And if they close on a real estate transaction during the term or the protection period, you get paid. So they can cut you out completely. They can put, Florida and anywhere from $1 million to $10 million, and they can buy whatever they want, and you get paid once this agreement is signed. That's the way this works.
Perfect.
Hey, Sam.
Yes, sir.
It was Mike O'Rourke. My question was, when you sign a buyer broker agreement with your customer, then do you have an obligation to let the listing agent know that you have that agreement in place? Is there a need to do that? Because your agreement is with the buyer in the first place. It's really not with,
I don't see any harm in my initial thinking about disclosing the existence of the agreement. Any listing agent who's familiar with a buyer broker agreement knows it's going to be exclusive. So that actually might put the listing agent on notice that they shouldn't be poaching your client when the client comes over to look at the property, maybe without you or something. What I would not do, I would not tell them what you're getting paid. I probably would not, as an initial matter, say, yeah, I'm getting X percent. Regardless, I would say, I expect to be paid my co-broke based on what you offered in MLS. Because the MLS, again, nothing's changed. MLS still exists. Co-broke still exists. And so getting everything, being upfront that the agreement exists is fine, but don't tell them how much you're getting paid, I would say.
Thanks.
Let's see here. Della, please, how to complete the form for expectation of X commission and seller's offering is less. So, Paula, Della, you have an agreement with the buyer once this is signed. You're in contract with the buyer. They agree to pay you X percentage, no matter what else you get paid if they close on a piece of property. So fast forward, you've signed a contract, you go to closing, the listing agent is offering something less, then you go to the buyer and you say, listen, you owe me X. Seller's paying Y, you owe me the difference. It'll be on the closing statement. And then they can be upset about it or not, but that's what they agreed to. All right, Maria is saying, if no commission is offered and your buyer can't afford to pay the commission or flat fee, can you put together an agreement with the listing agent to get? Absolutely, Maria. This is exactly if anybody sees Maria's question, this is exactly the point. You're going to be negotiating your commissions. That's the future. And then Bob is asking, is neighbor still requiring minimum listing of MLS of $1? Bob, I believe it's 1 penny, I think is what neighbor is requiring. So I don't think it's $1 anymore, but check with MLS on that. Don't take my word for it.
Quick question.
Yes.
If the buyer broker agreement has commission percent X and the listing has a percentage of Z, if we do not collect the difference, what are the ramifications?
Well, you've let your buyer walk with more money. That's it.
So if we, and it's not something we have to do with every single, let's say, you know, for example, the VA buyer can come up with a certain percentage, but not the whole thing, and another buyer can come up with the whole thing. So is it treating everybody fairly if one can and one can't? That's my question, where we are gonna fit in that.
The contracts specifically say that you, the realtor, are not exclusive to the buyer. The buyer is exclusive to the realtor. So obviously, you're going to be incentivized to take the buyer that can afford to pay the higher commission, and that's just the way it is. And there's no rule against that. It's just that's what happens.
Okay.
Okay, let's go back to the comments here. Do possible changes in the lawsuit also include other property types? Pam, so far it's residential, but I would imagine it applies to all compensation, offers of compensation in the MLS. The focus has just been on residential because it's such a huge portion of the market, but the lawsuits do not seem to specifically say residential. Roy's asking, when will NAR appeal? There was a blurb on Twitter that said they're appealing like this week. I'm not sure if that's true or not, but it was from Inman News, so we'll see. Let's see here. Will
Hi, Sam.
brokerages, Michelle? Oh, yes, go ahead.
Hi,
Stephanie?
thank you. Thank you for everything that you do. I have a question. So obviously there's a lot of fear mongering going on. And even in Florida, there hasn't been any definitive ruling made yet. As you clarified, the judge hasn't made a final ruling. So how
Right.
can so many people be making all these changes?
Well, we know what the problem is because the court has ruled and we saw the arguments in the case. So we know the issue is really buyers agents telling buyers that their services are free. At the very bottom, at the crux of the case, is the non-disclosure of the commission payments to buyers. And that results in buyers paying, according to the lawsuit, I'm not saying I agree with this, that results in buyers paying more for properties because commissions are inflated, so sellers are charging higher prices. That's what the lawsuit says. Agree with it, don't agree with it. The judge agreed with it and the jury agreed with it, but that's what the lawsuit says.
Okay, thank you so much.
Yeah, it's very scary. I'm not sure that I agree with what they said, but that's what they said. Nicholas is asking, can we add buyer is not obligated to pay the difference in commission offered by seller per MLS to the special? Absolutely, Nicholas. You freedom to negotiate your commission however you see fit that your broker allows. That's really what the lawsuit is about. Making sure that commissions are negotiable. Chris, I'm not familiar with any changes to the transaction brokerage or agency relationships as a result of the lawsuits. You will still be a transaction broker under state law and you'll go forward. So I wouldn't expect any changes there. Mary Ellen is asking, are 0% brokerages safer than the brokerages that charge percentages from their agents? Are you talking about the co-brokes, Mary Ellen, or are you talking about the commission splits with your brokerage? If it's the commission splits with your brokerage, that's just an agreement you work out with them. I don't know anything about that. But if you're talking about the commission split, the co-brokes, then I'm not sure that offering 0 saves you anything. I think that you're going to want buyers to bring their buyers agents to bring their buyers. So I would offer a co-broke. Okay, we are bumping up against 8 o'clock. I know you all have to go sell some houses. Please remember me if you have closing questions. And we're gonna let's see. Well, there's more questions coming in. Oh, brokerages getting sued, Barry? Yeah, I wouldn't. I don't know, and I don't know if there's going to be clawbacks. So be very careful, about what happens in the future. Stay informed, stay on the news. But all right, everybody, thank you all so much. I really appreciate it. I really appreciate the opportunity to work with you all, and I am excited for the future. Go sell some houses, and I'm around if you need me. Thank you.